An executor's deed is a deed that's written by the executor to the heir or to people who are entitled to the property. It's going to come into play typically in two situations. The first situation an executor's deed may come into play is where the executor is going to sell the property. It may be the deceased had a home, it may be the deceased has multiple children or multiple heirs, and it's easier, frankly, to sell the house. The kids don't want the house, so the executor, with court authority, and in most wills that's going to be implied and assumed if it's a good lawyer-drafted will, the executor can sell the property and sign an executor's deed to the buyer. That way, all the heirs don't have to come in. The family does not have to all come in and all sign separate deeds. The executor handles the listing, the executor handles the closing, the executor writes the deed to the new buyer, we're done. But the other place an executor's deed can come in is when somebody passes away and the kids do want the property, or they don't want it sold right away. And in that case, the executor takes the deceased real estate, and sometimes the legal correct term is real property, and the executor writes a deed to Jimmy, writes a deed to Johnny, writes a deed to Mary. There are the three children of the deceased. There was no surviving spouse. Now they each own a third of it individually. Typically is something called tenants in common. We have another video on tenants in common. You may want to check that out too.